And welcome. My name is Romy Furter.
And I'm Paloma Palmer.
We're research assistants at the Salvatore Center, which is sponsoring this talk.
Our speaker today is Professor Corey Brettschneider, a professor of political science at Brown University, who has written a number of political philosophy books and constitutionalism, including When the State Speaks, What Should It Say, and Democratic Rights, The Substance of Self-Government. Professor Brettschneider got his PhD from Princeton and his law degree from Stanford, and he's actually a graduate from Pomona College.
Professor Brettschneider has been back on campus a number of times since his graduation, and today is going to be talking to us about his new book, The Oath and the Office, A Guide to the Constitution for Future Presidents. And the book looks at a guide to future presidents, which looks at the role of the executive in the context of the Constitution and of general American history. It walks through the president's relations with the Constitution and the Constitution's relationship with the president. Throughout the book, we get a picture of a Madisonian executive branch and a president who is bound not only by the Constitution, but by the duty to uphold it. Please welcome Professor Brettschneider.
Thank you. Pleasure to be back in Claremont, although I would have preferred better weather yesterday, but it's still nice to be here. Thanks to George and Paul, who is my teacher, who really inspired me to be doing all of this, so it's especially nice to come back here. Let me start out by just making a quick observation. My guess as I look around this room, I'm just looking into some of your eyes. I met a few of you last time. There's at least one person in here who thinks, you know what, I could be President of the United States. And frankly, at least one. Yeah, in this group, actually, no, it's probably 10%, I'd say. And you might be thinking to yourself, you know what, these days, some of you might be thinking, or at least one of you, it's a somewhat low bar. So why would somebody want to be President of the United States? I think a lot of young people are attracted by Air Force One, the thrill of the power, the sort of status of the White House, and the power of the office itself, of course, which is familiar to us. So think about the nuclear trigger, which is in the sole control of the President of the United States. There's no review by Congress or anyone. It is the most powerful position, certainly in the country, and I would argue because of that nuclear trigger and control over the military as Commander-in-Chief in Article 2 in the world. Many people are attracted by the power. You might also have a sense of policy goals that you want to pursue, basic income, the Green New Deal, or market-based policies. But I'm going to talk about a very different idea of the presidency from one that's about power or about the usual way that we talk about leadership. And that's to restore the constitutional ideal of the presidency that's found in Article 2, which creates the office, and importantly, I'm going to argue, which also limits it. That the powers of the president are granted by Article 2, but also limited by it. And more than that, the goals of the presidency are also defined in Article 2 and by the Constitution more generally. And more specifically, what I'm going to argue is that the oath of office, which is taken every 4 years, is something that we hear all the time, but that we haven't internalized and we haven't paid attention to when we look at who we're going to elect as president. And Article 2, and in particular the oath, in particular every 4 years, defines the office in a very short sentence, but it really tells us what this office should be, and when you hear it and when you pay attention to it, you'll see what it really isn't in the modern presidency, certainly in the last several decades. I'm going to read it to you, and I don't want to flub it, because part of the point is that lots of officers in the federal government and in state governments take oaths that are similar to this one, but it's only the presidential oath that is defined word by word in Article 2 of the Constitution. Article 1, of course, creates the Congress. Article 2 creates and limits the presidency, and Article 3 creates and defines the judiciary. And this is what, according to Article 2, word for word, a president has to say. And the words, the precision of it is very important. You'll remember that Justice Roberts flubbed the words at one point during one of the Obama oaths, and they had to redo it because there was concern in the Office of Legal Counsel that he wasn't going to be the president again, if he wasn't going to be the president if the words were misspoken. So these are the words. Pay attention to them as I read them, even though you've heard them many times. I do solemnly swear, you could also affirm, that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. This isn't any kind of office with any kind of purpose. It's very clear what the purpose is. It's to preserve, protect, and defend the Constitution. Not to just pledge to not violate it and not run afoul of courts and obey judicial orders, but to go beyond it, to interpret the Constitution for oneself as president and to respect it and to promote it as the official who leads the executive branch. That's a very different idea of the presidency than the one I started out with and that many people have. And I'll just tell you, as a kid, it wasn't my idea of why I, as a 9-year-old, wanted to be president. And I'll tell you what inspired me, a very different idea of the presidency. When I was 9, my dad worked for a local politician, and the biggest event of the year, we lived in Queens, New York, was Queen's Day. It took place in the summer in Flushing Meadow Park, where the World's Fair had been held, and I was fortunate enough to get to be invited to walk with my dad and this politician in a parade with Mayor Koch. And to me, Mayor Koch was the biggest figure in the world. He was mayor of New York City, he had a huge personality, and I was walking behind him in the parade, and Koch, as he would walk, would throw his arms back and he would scream to these large crowds, "How am I doing? How am I doing?" I'm underneath, like, looking up at this just in awe. And, you know, it's July, we're sweating, it's deep summer, and the mayor says to the politician next to him, "You know, I'd really like some ice cream, vanilla." And politician turns back and says to this aide who's walking next to me, "Get the mayor some ice cream, vanilla." The aide runs across the field, like sprinting. I'm watching this guy, comes back, he somehow has the ice cream with him. He manages not to topple the vanilla ice cream that's on the top. He hands it to the mayor, and the mayor's just walking this parade, yelling, "How am I doing eating this ice cream?" And I looked up at him and I thought, you know what? I'd like to be mayor of New York City. And then later I started thinking, I guess I could be president too. And the ice cream, I think, is sort of a symbol of, by the way, there was another current president who would have been at that parade too. He came every year. Donald Trump, of course, is from Queens. But as I sort of thought about that ice cream, I thought, that's why I want to be, have this ice cream, the symbol that a lot of people have. That's not the idea of the presidency, even though it's the idea that I had. It might be why people run for mayor or for local office, but the presidency is different. It's got this defined oath that's part of it. And for me, the model of the constitutional presidency is really best defined in the second inaugural address by George Washington. It's the shortest ever at 135 words, and I'm going to read to you almost all of it. It's very short. And listen to what Washington says. This is taking place, by the way, in Philadelphia in the Senate chamber. The inaugurals were not huge events. This was he was directing himself to the Senate in particular and the House of Representatives, co-equal branches. And he says, previous to the execution of any official act of the presidency, the Constitution requires an oath of office. This oath I am about to take, and in your presence, that if it shall be found during my administration of the government that I have violated willingly or knowingly the injunctions thereof, I, besides incurring constitutional punishment, will be subject to the upbraidings of all who are now witness of the present ceremony. Think of that. That's almost the entire inaugural. And what he's saying is that I, George Washington, the man, am not the office. The office is distinct from me. It has a defined set of goals in the Constitution. And more than that, if I violate those requirements of the Constitution, subject me, George Washington, to constitutional punishment. The dignity inheres in the office, and if the person doesn't live up to them, stop me. Think of that idea of restraint, of defining the office through the Constitution and through the oath, and really saying challenging the people before. Subject me to constitutional punishment. If I fail, don't just criticize me. Of course do that. That's part of your role as citizens. But also, subject me to constitutional punishment. We'll get towards the end of the talk to the question of what to do when a president disregards the oath. But first I want to talk more about what the obligation actually is, affirmatively, to preserve, protect, and defend the Constitution. It inheres in a variety of different roles of the president. Perhaps in the modern presidency, one of the most important roles, the things that a president does, is use the bully pulpit. That is not an idea that's present in the 18th century. It is a 20th century invention, usually credited to Teddy Roosevelt, but really defined by Woodrow Wilson, who has a very different idea, the probably preeminent constitutional law scholar of his time, a professor at Princeton before he became president, the author of many books. And he had a vision of the presidency which would go well beyond the limits that Washington saw on it. I mean, really, for Wilson, he thought of the presidency as being a first office among equals. And part of his plan was to use the bully pulpit to expand the power into a kind of constitutional power, not just a series of one-offs. And the idea in particular was that by talking to the American people, he could rally the American people to then push Congress to push legislation through that he wanted. He also, in other ways, expanded the presidency when it came to the power of hiring and firing. He thought that the limits that Congress had placed on that ability of a president were mistaken. He pushed beyond it. But the bully pulpit is what I want to focus on, because I think in the expansion of the presidency and the creation of the bully pulpit as a constitutional role of the president, Wilson really strays badly from the oath that was taken. And that's an understatement. Woodrow Wilson not only shows the film Birth of a Nation in the White House, a widely known fact and reported, but less well known is that he's quoted twice in the film from his academic work celebrating the Ku Klux Klan. And why is that constitutionally significant? It's not just that it's immoral, it's that the Klan in its founding is an opponent. The whole purpose and reason for the Klan's existence is that they exist in opposition to the 14th Amendment guarantee of equal protection of the law. And yet here's the President of the United States not just quoted in a film celebrating the Klan, but celebrating the Klan himself and the film in the White House, and highlighting the fact that he's quoted in it. That's part of why he's showing it. So in other words, it's a use of the bully pulpit far from preserve, protect, and defending the Constitution, including arguably its most important provision, the idea that under law, regardless of gender or race or status or who our parents were, that we are equals. He really speaks against it. And so for me, one of the primary ideas of resurrecting this idea of the oath is to start to think about the role of the bully pulpit. The bully pulpit is particularly important in the modern presidency because our First Amendment guarantees a right of anyone to speak, including a right to speak against the Constitution in the way that the Klan certainly does and that increasingly hate groups do. A president has an obligation to respect the right of free speech, including criticism of him or her, including speaking out against the Constitution. And it makes it even more important than to use the bully pulpit to defend the Constitution against his or her opponents. And I'm going to talk about how that can be done. But free speech certainly creates a limit on how this can be done. You can't threaten to imprison your political opponents. The guarantee in the First Amendment that free speech not be abridged is binding on a president who has to simultaneously argue for your right to criticize, to say whatever opinion one wants, but also to defend the Constitution. Some presidents have missed that badly. John Adams signs into law the Alien Sedition Acts, and more than that, uses the acts. He asks his Attorney General to prosecute people who were mocking him or criticizing him, not just his policies, but him personally. He has Ben Franklin's nephew thrown into jail, a Pennsylvania newspaper editor. That idea now is recognized as a clear violation of a president's duty, I think widely by the court. Now why? The idea of free speech isn't just important for expression. The ability to criticize a president goes to the heart of constitutional democracy, and a president who neglects that really neglects constitutional democracy. Alexander Micheljohn, I think the greatest thinker of free speech in the 20th century, not just because he was a Brown professor, although I like that too. He gives this metaphor. He says, imagine that all of us are in a New England-style town meeting, and we're going to vote at the end about, this isn't his example, but it's mine, are we going to build a bridge on the north side of town or the south side of town? And imagine that the moderator of the meeting, in the midst of the discussion, is like, I think that all of these people defending the north side of town are stupid, and I'm going to just deny them the ability to speak. Meiklejohn's point is that doesn't just hinder the expressive value of the speaker, it hinders democracy itself, because how, if we're not free to hear and express all viewpoints, but also to hear them, how are we going to decide how to vote? How are we going to decide what our opinions are? How are we going to be democratic citizens? So shutting down free speech is shutting down democracy itself. Now, I'll tell you, the Alien Sedition Acts were designed in the following way. It was a crime to criticize the president, John Adams, but it was not a crime to criticize the vice president, Thomas Jefferson. And some of you are laughing. You know he was a member of a different party. It was a strictly partisan piece of legislation meant to really threaten American democracy. Now, more recently, thankfully, courts have, through New York Times versus Sullivan, a number of other cases, have made it very clear that there is a constitutional right to criticize a president. And part of a president's duty, in addition to generally defending the Constitution, is to defend the right, as Washington was, to criticize him or her. But at that same time, it even puts more pressure on a president to speak out against those who attack the idea of equal protection of law, to come back to that thing that Wilson violated. So think of what George Bush rightly did after 9/11. After 9/11, there was a huge amount of anti-Muslim sentiment, and Bush could have, like Wilson, catered to his constituency or part of it and played on that. But instead, he says Islam is a religion of peace. He uses the bully pulpit to defend the idea that we're all equals in this country, regardless of religion, certainly a guarantee of the Equal Protection Clause and also the Establishment Clause. Or think of what President Obama does when there is a video made in California, actually, depicting the Prophet Muhammad as a child molester. There are riots around the Muslim world protesting what's perceived as America's complicity in that film. And Obama makes a series of videos that explain the following thing, that we protect the right of free speech not because we agree with the speakers, and in fact, in this case, we protect it and also condemn it. He uses the bully pulpit to simultaneously protect the right, to defend the right of free speech, and also to condemn an attack on the idea of equality, regardless of religion. That's part of a president's duty, is to protect the right to free speech, to speak in favor of it, to simultaneously criticize opponents of the Equal Protection Clause. And in that, the president will partly be aided by courts. As I said, I think any modern Alien Sedition Act would be certainly struck down, although we could talk about Justice Thomas's recent remarks that suggest that he might not agree with that. But also the bully pulpit has to be used in ways where courts are not going to act. No court is going to force President Bush to say what he said, or President Obama to take these ads out. It's an independent obligation of a president to preserve, protect, and defend the Constitution. That brings us to another amendment, the way the book is structured, so I talk about the oath, the powers of the president, and now we're in the Bill of Rights section. The Eighth Amendment bans cruel and unusual punishment. What about torture by a president in order to extract information, for instance, waterboarding? Justice Scalia, who has a very different way of reading the Constitution, and a president is going to have to decide how he or she is going to read the Constitution. For Justice Scalia, you read the Constitution the way it was understood at the time it was written. You look very closely at the text, and in particular for him, as he argued on multiple occasions, including in a video that you could watch, 60 Minutes, says that he believes that actually the Eighth Amendment doesn't limit a president's ability to torture at all in order to extract information from, say, suspected terrorists. Now, why? Because punishment implies conviction by a criminal court, and after conviction, and suspected terrorists have not been subject to trial. And so he would not impose an Eighth Amendment limit on a president's ability to torture. And even though some of you might disagree with that, no court has ever done that. No court has ever said that the Eighth Amendment applies except in the context of a criminal trial. But to me, when you, as president, read the Constitution yourself and understand not just the text, but also its values that are enshrined in the text and the wider context of democracy, as Meiklejohn in that example does, you see through its history that the purpose of the Eighth Amendment comes from the British Bill of Rights, which itself is meant to limit kingly domination. Kings of England and many other countries used torture and unusual punishment, like ear chopping in particular was one, branding, in order to make people feel their subjects, to realize they were beneath the king, and that sedition, criticism of the king, would be met with the harshest form of punishment. Now, when in the American Constitution that language is really taken verbatim from the British Bill of Rights, it transforms even beyond monarchy to an idea of equality. And certainly a president, to me, who tortures, who uses that power to subjugate those even suspected of terrorism or of terrible crimes, undermines that core ideal, that core value of the Eighth Amendment being about respect for the equality of all citizens and the compatibility of that with all government action. Now, of course, a president has an obligation to defend the nation, but there are limits on how that can be done, and that includes limits on torture. That won't be enforced by courts. I'm realistic to know that, but yet a president has an independent obligation to preserve, protect, and defend the right reading of the Eighth Amendment. What about the Equal Protection Clause, which I've mentioned, and the role of courts? I do believe there is a significant role, and there has been traditionally, for courts in stopping presidents who violate the Equal Protection Clause. That hasn't always been the case. In the 19th century, Che Chiamping, a resident of San Francisco, gets permission to go back to his country and then return. He goes to the customs house. He's a property owner. He goes back to his native China, and while he's gone and coming back actually on the boat, Congress passes and the president signs the Chinese Exclusion Act. And when Che Chiamping arrives back into the harbor in San Francisco, he's denied entry. And he brings suit saying, hey, I have a due process right to come back into the country. And the court says, and to me, one of the least well-known, but one of the worst, up there with Plessy versus Ferguson and Dred Scott as the worst decision by the court, says the president basically and Congress have plenary powers to do whatever they want. And yes, of course, this would be a violation of the Constitution had he been within the borders. But the fact that he's outside the borders means that he has no rights. Now, to me, that is deeply tied up with the racism of the time. Of course, the Chinese Exclusion Act, based in a form of animus towards Chinese people generally. And over time, the courts work out a jurisprudence of equal protection that really starts to push away from animus. In fact, that's the primary thing that the Equal Protection Clause does at the federal level, at the level of the states. You can't make policy based on animus. And so when Justice Kennedy, in the Lukumi case, condemns a Florida legislature for discriminating against a minority religion, the Santeria, he says, you can't make laws that are clearly based in your own hatred towards a minority religion. They say in that case, the council people, that Santeria is an abomination against the Lord, and he condemns them for that and strikes down their ordinance banning a practice of the Santeria of animal sacrifice. In more modern jurisprudence, Kennedy also, in the Romer decision, condemns a plebiscite in Colorado that discriminates against gay citizens on grounds that the motivation for that plebiscite is animus. So what about the travel ban? I and a number of people argued, I led a brief in the travel ban case that was eventually signed by almost 100 scholars, made the argument that it is time to reverse Che Chiamping and to make it clear that animus, whether it takes place within the borders or outside the borders, is a violation of a president's duty to respect people as equals and not to make laws based on animus. And we argued that President Trump's claims about the travel ban, both during the election and after, when he said he preferred the old travel ban, which was about a shutdown of Muslim immigration, that was a clear violation of the Equal Protection Clause. And I assumed, I really believed, that Justice Kennedy would have led the majority opinion in saying that this action by a president motivated by animus is unconstitutional. Now, that didn't happen. 4 justices agreed with our brief. Sotomayor cited it and used that exact argument that I just gave you, almost those words. 4 justices said we have to defer to a president. A version of the plenary power argument. They never cited Che Jianping, but that's clearly what they're relying on, is that kind of logic. And Justice Kennedy, in a really awful moment for the country and the Supreme Court, tried to hedge. He said, well, we need more evidence, but I'll vote for the majority for now, and then, of course, retired. What's the point of it? That we can't trust courts, even when they should act to stop a president, to do so. We have to trust that other mechanisms will help us. So how can we stop a president who repeatedly disregards the oath? Ideally, litigation, and I could talk about the emergency case that's happening right now. Hopefully, litigation will do some good, but we also need to rely on other mechanisms besides relying on the Supreme Court. The most obvious one is elections. In the election of 1800, the election focused on John Adams signing the Alien Sedition Act and using it to focus on political opponents. So I think that 2020 has to be a call to action, to return to the constitutional idea of the presidency, to return to the oath of office as the primary thing that we look at when we are assessing candidates, as happened in 1800 with the defeat of John Adams and the expiration and end of the Alien and Sedition Acts. But there are other things to do. There's a role for states in that same instance. The story doesn't just end with the election, that's part of it, but it's also that the sitting vice president, Jefferson, and James Madison, who did more to write and craft the Constitution than anyone else, including its free speech clause, including the later passage of the Bill of Rights, including the free speech clause, goes with Jefferson back to Virginia, and they draft what becomes the Virginia and Kentucky resolutions, declaring unconstitutional the Alien and Sedition Acts, and saying more than that. Not just are they unconstitutional, courts, by the way, were never going to intervene to stop that act. Samuel Chase, who's on the Supreme Court, is a chief advocate of the acts. The court is packed with Federalist judges who are deeply sympathetic to Adams. They're never going to strike it down. So they need this other technique. They say the acts are unconstitutional in the resolution. They do something more controversial. Jefferson, always the less subtle thinker, argues that they should say nullification. Madison convinces them, no, federal law is supreme. But we're going to say that within the limits of law, and while recognizing federal law as supreme, local police officers, local legislatures, local government doesn't have to cooperate with the federal government in putting people in prison who criticized John Adams. If the federal government wants to enforce that law themselves, they can figure that out, but we're not going to cooperate. So in the book, I talk about Miguel Marquez, the former judge on an appellate court in California, now the COO of Santa Clara County, who worked with San Francisco to bring a lawsuit against Donald Trump that says basically the same thing. Donald Trump, in his first days in office, signed an order that required local police to cooperate with ICE in the following way. If they suspected somebody who had been stopped for, say, a parking violation of being undocumented, the order requires them to hold that person for 72 hours until ICE can come and take them and deport them. If you fail to comply with that order, according to this executive order, you would lose your entire, not just some, but all of your federal funds. And even though the tradition of states' rights has an ugly history, Marquez realizes that there's this older version of it, the Madison and Jefferson story that I told you. And he brings this suit, now successful in district court in the Ninth Circuit, and maybe, I think, soon to go to the Supreme Court, on the grounds that the 10th Amendment gives the states the right to not be commandeered or co-opted by the federal government. And the threat of loss of all federal funds is such commandeering, unconstitutional. And so he relies on this use of the states to stop an unconstitutional president, combined with the concern about civil liberties, just as Jefferson and Madison used the role of the states in these resolutions to defend the First Amendment free speech clause. What about indictment? Now we're going to get close to some very heated issues. There is a controversy about whether or not a sitting president can be indicted for criminal offenses. And many scholars, especially when I wrote the book, and now I think the tide is changing a little, think that the answer is no, that a sitting president has immunity from criminal indictment. And it is true, certainly, that Alexander Hamilton had that view. He thought that a sitting president had to be impeached by the House of Representatives, a majority, removed by 2/3 of the Senate, and only after removal could then be subject to a criminal indictment. But James Wilson from Pennsylvania argued in the ratifying convention in Pennsylvania the following thing. He said a very simple principle that to me really determines the issue. Framers just disagreed. He said a president is not above the law. And given the disagreement between the framers about this indictment question, certainly there's nothing in the Constitution granting immunity. We have to start to look beyond just the text, beyond just the intent of the framers, and to ask, what's right to do here? What does the Constitution's values require? And that idea that the president is not above the law, the president is an equal, controls it for me. Now, I will tell you realistically that the Department of Justice, its Office of Legal Counsel, has 2 memos that many believe are binding on Robert Mueller right now that say the opposite. They say a president, first of all, is the head of the executive branch, these memos, and can't be indicted because as the head of the executive branch, we would disable the entire executive branch. And that's not a small argument. The executive branch has more than 2.5 million employees. It is by far superior in number and power to any other branch of government, not even close. And their point is indicting this president will disable the branch. Now, what I say about that is it's simply wrong. As the Clinton v. Jones case showed, a president can manage a schedule with the courts and work with courts to allow the indictment and also still pursue his or her duties. The nuclear suitcase is moved around the world. Amazing feats are accomplished. It's been done in snowstorms, and it's possible to coordinate how the indictment process would work with a president's schedule. The more famous argument is a dignity argument, which is even more wrong, and you see this when we return to George Washington's address. The argument is that the office of the president is so dignified that a president is immune from indictment. But what's wrong about that is it places the president above the people and actually gets dignity exactly wrong. As Washington says, dignity inheres in the office, not the person, and in fact the indignity is to the people who are supposed to criticize a president, subject a president to constitutional punishment if a president is allowed to go unpunished for this deed. And I should point out, too, that not indicting might allow the statute of limitations to pass by 5 years on many of the crimes that we're talking about these days. And so it might be impossible to, even after a president has left office, to indict him or her. Let's turn to impeachment. I'm happy in the Q&A to talk more about any of these issues, of course, including indictment. Impeachment, I think Washington might have meant indictment. He doesn't clarify, certainly, in the speech. He certainly was talking about impeachment, subject me to constitutional punishment in addition to your upbraidings or criticism. And I'm not going to say too much about this except to point out its difference from the criminal indictment question. To me, a high crime and misdemeanor, the standard that the Senate and the House of Representatives are supposed to use both in the impeachment question in the House and in the trial or removal question in the Senate, it sounds like a legal standard, and the words trial and impeachment have a sort of parallel to indictment and criminal trial, but they are different. And in a way, in addition to Washington, the hero of the book is Frederick Douglass, the 19th century abolitionist and civil rights advocate, who says about the impeachment of the first President Johnson, Andrew Johnson, you've got it all wrong. Everyone was talking about how Johnson had violated a law that required him to seek the permission of the Congress in firing his Secretary of War, and he refused to do that. He just fires him outright, a holdover from the Lincoln administration. And the focus of the impeachment is on this very legalistic question. It's probably the case that we know now that it was constitutional to fire him and that this law limiting it was unconstitutional. And Douglass sees that this technical issue isn't really what's going on at all. Johnson was traveling around the country giving the most racist speeches that you could imagine. They make the so-called alt-right look moderate. They were that heinous. They were advocating really a return to the old order, to slavery, and along these deeply, deeply racist, hateful speeches that the President of the United States is giving around the country, he also is refusing and undermining, through his inaction, to implement the 13th Amendment undermining slavery. And Douglass makes the common sense point, which is that a high crime and misdemeanor is this. It is a degradation of the oath. That's what is going on with Johnson. And let's say that. Let's not focus on this legalistic stuff. And there is no high crime in the criminal law. If you take 1L criminal law in a law school, you won't study high crimes. That's not a category of the criminal law. It's a distinctly political category that is about the oath of office and degradation. And I'm with Douglas in thinking that that's the real issue in thinking about impeachment, that we have to think about the purpose of the office and think about constitutional punishment as constitutional punishment, defense of the Constitution, the obligation of a president to preserve, protect, and defend the Constitution. So that's been a long tour, and the book, of course, is much more in-depth, but it begins with the oath of office, returning to this idea that 2020 needs to be a referendum on the Constitution. We talked about the powers of the presidency and the bully pulpit in particular, and its importance in preserving, protecting, and defending the Constitution, especially given the complications posed by the president's parallel obligation to defend the right to criticize him or her. We can't shut down speech. We also can't shut down speech rightfully that is against the Constitution, not just against the president. So a president has to both protect free speech and also criticize opponents of the Constitution. We talked about why, even though courts would enforce that, would strike down the Alien and Sedition Act, why sometimes a president won't be stopped by courts, and so it's especially important to find one that will preserve, protect, and defend the Constitution. That was the Eighth Amendment example, and in particular the idea that courts are not going to enforce a ban on torture, but a president respecting the Constitution needs to not torture and to guarantee rights against torture. We talked about the Equal Protection Clause, my hope that courts will reverse Che-Champing at some point, but their failure to do so, and how that also puts pressure on a president. And then finally, we talked about how to stop a president who disregards the oath of office, because sometimes the American people won't elect a president who is constitutional in their thinking and acting. And that includes the role of elections, certainly 2020, the role of the states, the indictment. Yes, a sitting president can be indicted, in my view, despite these DOJ memos. And finally, impeachment, the idea that that is not a legal process. It's a political judgment about the oath of office. So thanks for listening, and I look forward to questions and comments and talk about many of the things that are in the news if you want to. Okay.
We'll be taking questions now.
Okay.
Thank you for your talk.
Thank you.
You talked a bit about how citizens can kind of vet candidates on a more constitutional sense, and I guess my concern is that for within our bubble here at like Claremont McKenna College, sure, we have like a knowledge of what the Constitution is and like how to uphold the oath of office, but like in the broader American electorate,
Yeah.
how do you raise that issue, and do you think it comes from more robust civic education, or what do you think? How can that be bridged?
Yes, I mean, that is what I'm all about, is robust civic education. And the reason I wrote this book, I've written previous books, mostly for other academics, professors, for students like yourselves who are studying topics like political philosophy. But this book isn't written, and you can probably tell from the talk, in that style. It's written through stories. It's written in a way to try to engage young people, certainly high schoolers, certainly college students. And my thought is, you know, the way that presidential history, presidential thought has developed, what you see on television, is not about the Constitution at all. It's about other goals that are, you know, laudable maybe, but the office is defined by the Constitution. And so American democracy can't survive, I think, without a basic understanding of not just the rules of the Constitution, how old the president has to be. I think people know things like that. But the principles and values that are underneath the Constitution. That's the way that we're going to defend liberal democracy. We can't just trust that there's some sort of self-executing mechanism that's called the Constitution. I say in the book, there's no Constitution police. That's not a thing. The idea that always the court, for instance, is going to defend the Constitution. No. It's up to the American people. And yes, no question, there is a crisis in civic education, a crisis in our failure to understand the document. But, you know, that's a call to action to me. That's something that we have to stop.
Hi, Professor. Thanks so much for your talk. It seems that in your argument, you've sort of bypassed the first clause that calls on the president to execute the office of the president.
Yeah.
Do you see the second clause as being a constituent, or the first clause as being a constituent part of the second? Or do you think that the first clause allows the president maybe larger powers as he or she sees fit, for example, in the case of immigration, to either enforce the borders as he or she sees fit, or to allow certain people to stay as he deems so?
Yeah, no, certainly they go together, I think. There is an obligation directly to preserve, protect, and defend the Constitution, not to violate it. But part of what that entails is limits that come from statutory law. And so respecting the office and faithfully executing the office is very closely tied, as I say in the 3rd chapter in the book, right in the beginning, to the idea of faithfully executing the laws. So I tell the story in chapter 3 of the Youngstown case, which, and you'll see the relevance to your question in a second, the most relevant case, not just to your question, but to the question of the border wall and the national emergency that's just been declared a few days ago. Now, Youngstown is, the majority opinion is important, I'll talk about it, but there's a concurrence by Justice Jackson, who had just been a very unusual position to be in. He had recently been the chief American prosecutor in Nuremberg. So when he decides this case, Youngstown, which is about President Truman, says that there's a strike going on. It's the time of the Korean War. There's a strike in steel mills. And he says, look, the strike is impeding our ability to generate enough steel to make arms so that we can win this war. This is a national emergency, and he relies on a statutory act similar to the one that President Trump just relied on, although the specific act Trump relied on was passed in the 1970s, the National Emergencies Act, after the case. But Truman has a similar statute, and he says this is a national emergency, and he signs an executive order seizing the mills. He takes control of the mills, he ends the strike, and he starts up steel production. And there's a case that says, hey, you can't do that. Now, can he do it? There's a statute on his side. There is certainly an emergency and a question about war, of fundamental power of the president. But what the court says in the Youngstown decision, and this isn't just any opinion that I'm picking, it is the law. It's the current statutory and constitutional law of the, and most important case, limiting the president's power. It says the following thing, that a president's power is at its lowest point when Congress says no. And so the question here in the Youngstown case is, did the Congress say no to the President of the United States when it came to this ability to seize the mills? And it turns out that the Congress had considered granting the President that specific power. In considering a piece of legislation, there was an amendment proposed that would have given the President the possibility of using the power of the office to seize mills in a national emergency. And what the court says, and what Jackson says, is first of all, the Congress said no, and the answer is no. And most importantly, Jackson rejects the idea of inherent emergency powers of the president. Why? He, certainly didn't think that Truman was Hitler. They were friends. He had worked for Truman. But what he says is that it was the Weimar Constitution that granted a chancellor, Hitler, the power to basically declare national emergencies and usurp the Congress. And we're going to stay so far away from that because of this idea that Article 2 requires the president to faithfully execute the laws, that if Congress says no, the answer is no. So the question in our own national emergency, when it comes to recently declared, when it comes to the constitutional question of respecting the Constitution, is that question. It's Congress that makes the laws, not the president. The president executes the laws. And so the question is, did Congress say no? And to me, I'll just say my view of it, Congress considered certainly the possibility of granting Donald Trump the ability to reappropriate funds to build the wall, and they said no. That's plain as day. And so there's an exact parallel with the Youngstown case, aided by the fact that it's Congress that not only makes the laws, but also that appropriates funds. So Youngstown, I think, is controlling. Now, that's not going to be an easy case. That's my constitutional interpretation. I think there are pretty clearly 4 votes on either side, and it's going to come down, frankly, to what Justice Roberts thinks about this. But Jackson is a hero not just on the on the left, but also on the right. He really transcends party boundaries. You heard Justice Gorsuch and I believe Kavanaugh praise him in their hearings, both of them. And Jackson is really known for one case, and that's this. This is his most important case, the most important case about presidential power. So I think that the court will rightly say that this is an unconstitutional reappropriation of funds.
Hi, thank you for your talk. I'm curious to what extent it matters what the oath of office is said over, whether that's a Bible or something else.
Certainly there's no requirement that it be said over the Bible, and if you listen to the oath, it doesn't say anything about a particular religion. And our First Amendment guarantee of the requirement that we have no official church, the guarantee, as the First Amendment says, that Congress shall make no law respecting an establishment of religion. That really is about the idea that, and also the idea that we don't have religious tests for offices. That absolutely not. That symbol of taking the oath, you certainly can volunteer. You have a right to free exercise. The president can do it if he or she wants, but there's no requirement that a Bible be used. And in fact, recently in the Senate, I believe, a newly elected senator took the oath on the Constitution.
That was our last question for today. Thank you again, Professor.
Thank you
for
all.
being here.
Thanks so much.